chapter 1, we will see the introductory part of criminal procedural law. Once we need the phrase criminal procedural law, also the importance of laws on all human issues that is substantive procedural law. We will see there are also two criminal justice models, which models that we recognize under Ethiopian criminal procedural law, whether it is the due process one or crime control model. We see this also under chapter 1. Again, there are sources of laws and development of laws, criminal laws. What was the development of criminal laws during the reign of Haile Selassie and III? We will see as to how the Zen police public prosecutor conducts investigations. We will see mechanisms. And in chapter 2, we will see setting justice in motion, how justice in motion. After the police or public prosecutor communicating information about the crime, how police is going to conduct an investigation, how police is going to prefer charge against the accused person. And as we try to distinguish, differentiate suspected person from that of an accused. And chapter 2. Again, we'll try to see the summon, arrest, how summon going to be served, how an arrest effected by the police, how individual person arrest suspected person or not. The only police or arrest an individual person whom criminal procedural laws endowed is such power. We will see under chapter 2. Again, under chapter 2, we try to see the police investigations. The criminal procedural laws which was enacted during the reign of Haile Selassie as empowering only police to conduct investigations. But currently in Ethiopia, there are several special proclamations as empowering people together without police to conduct investigations. We will see. Also, there are also under chapter 2 another sub topic we will see the conventions. How conventions is going to be conducted, and interrogations, saving the seizures of other properties. Under chapter 3, we will try to see the post-arrest procedure. That is, the includes or refers to my custody of the bail rights and habeas corpus. Under chapter 5, Under chapter 5, we try to see how criminal charge going to be terminated by the prosecution as well as by the victim himself or himself. Is that arbitration is possible for criminal matters or not? And we will see the primary inquiries under chapter 5. Under chapter 6, we will see charge. How charge prepared. As you know, under criminal procedural law, there's an article 222 and 27 or statement of defense 234. There are certain procedures that has to be followed by the individual during the paper statement of claim or that of defense. As well, when public prosecutor prepare charge, certain procedure has to be followed by the prosecutor. We will see how charge can be prepared by public prosecutor. In case when public prosecutor need to amend said charge, certain procedure also followed by public prosecutor. We will see this part also in detail. Under chapter 6, the federal system, the jurisdiction of courts, the jurisdiction global. Under chapter 7, the TIGAN stage. Post, we will see under chapter 7. And the final one is post-judgment procedure. After the judge rendered the decision against one accused person who executing the decisions of the court, is that police or prison administration institutions, or is there any other police we see? And that's the last chapter. And mode of assessment, last participation of the 5. Now assignment, exam. This is what the syllabus of the course. A review, especially therefore, we will begin chapter 1. Definition, the nature, purpose, development, criminal procedure. What is criminal procedural charge? How do you understand the phrase criminal procedure? How do you define criminal procedure? እኔ እኮ ሶስተኛ ዓመት አራተኛ ዓመት ምናምን በእናንተ እኮ ነው የሚሄድኩበት ቦታ ሁሉ የምሞክረው። እኔ ስመጣ ግን አስተናግዶ ምን ምናምን ባለፈው 0-0 ልትዋችሁ ለብዙዎቻችሁ አክቲቪቲ ኢንቴንሽናሊ እንደዛ ያደረጉት ለሁለት ተማሪ ናቸው። እኔ ስመጣ ዝም ትላላችሁ። It is a rule governing and mechanisms under which crimes are investigated. Under which crimes are prosecuted. adjudicated. Sentenced or punished. All these points can be answered by criminal procedure. Therefore, the criminal procedure that shows as to how public prosecutor going to investigate the crimes. After the communication, after the information about the commissions of the crime communicated to public prosecutor or that of the police, right? The police, together with that of public prosecutor, going to conduct an investigation. Therefore, under the old criminal procedural law, as I told you, only the police or investigating police officer alone are empowered to conducting an investigation of the crime. But in the current situations of Ethiopia, okay, the regional states as well as the federal government, Addis Ababa and Regawa, both public prosecutor, okay, public prosecutor together with that of the police going to conduct an investigations. Therefore, police and public prosecutor conducts investigations. You can see Article 14 of Criminal Procedural Code and Article 211 Criminal Code, Substantive 1. Based on these two provisions and other special proclamations, public prosecutor and police empowered to conduct an investigation. Prosecutor, only police, only public prosecutor instituting charge against to an accused. Police only partake on the investigations of crime rather than preparing charge. Only public prosecutor empowered to prepare charge against to an accused person. Suspect is below. Police investigations are suspect the prosecutor. After public prosecutor prepare charge against to an accused person, that individual called as an accused. Therefore, only the laws under Article 211 Criminal Code and Article 40s of Criminal Procedural Code that empowering public prosecutor to prepare charge against to an accused person, against to the individual or person who is suspected by committing the crime. Adjudicated the power given to the courts. The court going to give the case and finally passed the verdict judgment against 150% for an individual. Punishments or sentence might be fine or simple imprisonments. It might be the rigorous one. Simple imprisonment, as it says no. One is 2 years. That. From 10 days to 3 years. In case of the rigorous one, from 1 year to 3 months. Therefore, the judge, after found the guiltiness of the accused person, going to impose the punishment or the sentence against two accused. The main actors in criminal justice system in Ethiopia are the main actors in criminal justice system in Ethiopia. Police, public prosecutor, public prosecutor, Therefore, police not only to conducting an investigations, but also protecting crime. Therefore, these three organs play the greatest role in ensuring or securing the criminal justice. Not only these three organs, but also other state organs can also partake in the issue of the criminal justice system. But the three of these bodies, that of course, is the main actors. Second point is due process of law. Due process of law as composed of the first one is substantive, due process of law, and the second one is procedural due process of law. As you know, under introduction to laws broadly divided into two parts. Laws broadly divided into two: the substantive and that of adjective. Again, the adjective law divided into the procedural one and that of evidence. Do we have the procedural question? Does Ethiopia currently has a codified evidence law? There is no codified evidence law in Ethiopia, but the evidence laws scattered in the substantive and the procedural laws. Therefore, the law that regulating as to how to collect the evidence and as to how courts that use evidence laws scattered in this area, the substantive and procedural laws. Therefore, these substantive laws, it define rights, duties, and liabilities of individuals. The substantive law, it refers to the subject matter of the content of some laws, except procedural laws or adjective laws. Except procedural laws and evidence laws, all laws categorized under substantive laws. Hullum good substantive nature, except the procedural and evidence. For instance, criminal law, civil code, family code, and others. All laws except procedural and of the evidence, the remaining laws categorizing under substantive laws. Therefore, these substantive laws define the right, duties, and the liabilities of individual. When individual person violating their duties, the law is going to impose certain penalties or punishments. Again, these from the adjective laws, the procedural one, and the evidence laws, the procedural and evidence laws for the implementations. The implementations of substantive laws. The two laws, that is the procedural one and the substantive laws, is served as a means to achieve substantive laws. Therefore, what does it mean when we say the substantive due process of laws? This substantive due process of law, it refers the content or the subject matter Therefore, the subject matter of, for instance, the criminal law, the family law, criminal code is called as the substantive due process of laws. For this substantive due process of laws are protecting people from arbitrary, unreasonable, or you may say capricious, unpredictable laws, and tyranny after. These substantive laws that protect the citizens, the people, from arbitrary act of government, from unpredictable laws. For instance, the cases that happened in the 1920s in the United States, the case between public prosecutor versus Keria Buck in 1927 in the United States of Virginia States. This case talks about The Kenya books were at that time she was 18 years. And then Kenya was 18 years old. She was residing in the United States, in the state of Virginia. She was a feeble-minded girl. Kenya then was a feeble-minded girl. And her mother also, she was a feeble-minded, that is, lack of mental tools because of her disease. Therefore, the circuit of the Virginia State Court decided against Kenya. Okay? She must be sterilized because of epilepsy disease, because of her mind. Okay? Her mind is not mature, that is feeble-minded. She has to be sterilized. And then the Virginia State Supreme Court, after the courts seen the cases by an appeal, it also approving the circuit court or the lower court of the Virginia States. This one is a substantive law of the Virginia States. Okay, clearly prescribed that any individual person who residing in Virginia States, when their mind lacks certain maturity because of this, like feeble-minded, epileptic disease, okay, they have to be sterilized. Medical sterilization. Vision diagram mahal ini ህዝብን ሀገርን ዜጋን ያጥፋል ተብሎ ስለዚህ ፍርድ ቤቶች በቨርጂኒያ ስቴት ሕግ መሰረት feeble-minded ሲሆኑ feeble-minded epileptic እንደዚህ በሽታዎች በሚሆኑበት ጊዜ ስትራላይዝ ይሆናሉ። ልጅ እንዳያገኝ መሀን እንዲሆኑ ይሆናሉ። ታዲያ 18 years old ልጅ እናቷም feeble-minded እሷም። ስለዚህ የአሜሪካን ዜጋን ያበላሻሉ እንዳይወልዱ ተብሎ ስትራላይዝ እንዲሆኑ በፍርድ ቤት ተወሰነባቸው። ሱፕሪም ኮርት ቨርጂኒያ በዚህኛው ላይ ያለው ስታት ህግ ትክክል ነው፣ ምንም ስህተት የለውም ብሎ አፕሮ ማድረግ ልዩቷ እናቶች ስትራላይዝ ተደረገች። በኋላ ግን ክሪቲሳይዝ የተደረገና ህጉ ሰብስታንቲቭ ፕሮሰስ ኦፍ ሎ የለውም፣ ኢት ላክስ ሰብስታንቲቭ ፕሮሰስ ኦፍ ሎ ተብሎ በ1927 ከዛም በኋላ ያሉት አሜሪካ ግዛት ውስጥ እንደዚህ አይነት ህጎች እንዳይኖሩ ተደረገ። Their validity of substantive laws can be challenged when it is against to the constitutions of Ethiopia or that of the United States. Therefore, the due process not only to exist in the procedural part, but also it needs to determine whether the substantive law enacted by the lawmaker is the valid one or against the constitution or not. Due process of law ተከትሎ ያለው is a valid laws, is a not contradicting constitution or international instrument that by Ethiopia for instance. የሚለው ቼክ ይደረግበታል፣ ቻሌንጅ ይደረግበታል። ስለዚህ ሰብስታንቲቭ ህጎች የሰው ልጅ መብትን የማይጋፋ የተፈጥሮ ህጎችን የማይጋፉ መሆናቸውን የሚረጋገጥበት ዲው ፕሮሰስ ኦፍ ሎ ያለው መኖር አለበት። ለዛ ነው አሪዝናብል ህጎች ሲወጡ ፕሪዲክተብል የመሆኑ ህጎች የሌሉ ሲሆኑ አርቢትራሪ ህጎች ሲኖሩ ቻሌንጅ ይደረጋል፣ እንዲቀየሩ ይደረጋል። ኢምፕሊመንት ማድረግ ሲያስቸግሩ ይቀያሉ። ፕሮሲጀራል ሎ አንደር ክሪሚናል ፕሮሲጀራል ሎ አይታችሁናል። አንደር ፕሮክላሜሽን 25 የተቀየረው በዚህኛው ጋር ሳይጠቀሙ ማለት ነው። እዚህ ሳይጠቀሙ በፊት ታምራት ላይ ጠቅላይ ሚኒስትር ሲከሰስ ሚኒስትሮች የመንግስት ሚኒስትሮች ሲከሰሱ በቀጥታ ክሱ የሚቀርበው ፎር ፌደራል ሱፕሪም ኮርት ነው። ፌደራል ሱፕሪም ኮርት ከወሰነ በኋላ ይሄ ሰውዬ ይግባኝ ወዴት ነው የሚወስደው? የት ይወስዳል? ይህ ነው የሚወስደው። ምን አለ ከዚህ በላይ ፍርድ ቤት አለ? ኢሮ ብሎ ብቻ ካለ ነው ይወስዳል። ካሴሽን ዲቪዲ ይወስዳል። ራይት። ስለዚህ ፌደራል ሱፕሪም ኮርት ከሚከሰስ ይሄ መከሰሴ አለ ሰውዬው ፌደራል ሱፕሪም ኮርት ዳይሬክት መቅረቤ ራይት ቱ አፒል ሪስትሪክት ያደርግብኛል። ስለዚህ እዚህ መከሰስ የለብኝ ፌደራል ሃይ ኮርት መከሰስ አለብኝ ብሎ ተከራከረ። ከዛም ወደ ሃውስ ኦፍ ፌዴሬሽን ኬዝ ተመራና አዎ ሰውየው ህገ መንግስታዊ መብቱ ራይት ቱ አፒል ወዴት ነው የሚወስደው? if there is error of facts በዳይሬክት ፌደራል ሱፕሪም ኮርት ከተፈጠረ ወይም ደግሞ የኤቪደንስ ሲመዝኑ ዳኞች ከተሳሳቱ ሌላ ቦታ መውሰድ የለም አይችልም። ያለው ቀጥሎ ካሴሽን ቤጅ ነው። ካሴሽን ቤጅ ደግሞ ኢሮቭ ነው። ስለዚህ መብቱን ሪስትሪክት ያደርጋል። ኮንስቲቱሽናል ራይቱን ቻሌንጅ ያደርጋል። ዲው ፕሮሰስ ኦፍ ሎው የለውም። ስለዚህ አዋጅ 25/6 ስር ያለው ሰዎቹ በፌደራል ሱፕሪም ኮርት መከሰስ አለባቸው የሚለው ሃውስ ኦፍ ፌዴሬሽን አነሳና ፌደራል ሱፕሪም ኮርት ሳይሆን ፌደራል ሃይ ኮርት እንዲከሰሱ ህገ መንግስትን ቫዮሌት ያደርጋል። ሰብስታንቲቭ ዲው ፕሮሰስ ፕሮሲጀራል ዲው ፕሮሰስ ካን ቢ ቻሌንጅድ ካን ቢ ሬክቲፋይድ ባይ ዘ ኮርት። ያ ማለት ነው ሰብስታንቲቭ ዲው ፕሮሰስ ስንል በሰብስታንቲቭ ውስጥ የወጡት ከህገ መንግስቱ ጋር የሚጋጩ ሲሆን እንዲስተካከሉ፣ እንዲፈርሱ፣ እንዲሻሩ ያደርጋል። when it is an arbitrary one. When the law is substantive law, it is an unreasonable one. When it is unpredictable, capricious one. ስለዚህ የሚመለከተው አካል ከህገ መንግስቱ ጋር ይጋጫል ብሎ የሚያስቀሩ አዋጁ ወይም ደግሞ ስፔሲፊክ ፕሮቪዥንስ ሪፒት እንዲሆን ማድረግ የሚችል ማለት ነው። that is substantive one. Again, as I've told you, these substantive procedural laws can also determine or define the rights of citizens, duties, and the responsibilities or liabilities. And also determine scope of applications. These substantive laws determine the scope of applicabilities. በማን ላይ ነው የሚፈጸመው? የት ላይ ነው የሚፈጸመው? ይኖር ሊሚት ያደርጋል። Therefore, ሊሚት ሲያደርግ due process of law በውስጡ የያዘ መሆኑ ቼክ ይደረጋል። These all are what we call substantive due process of laws. And the second one is procedural due process of law. As you know, under procedural due process of law, this procedural laws almost is a means to an end. It adjusting for substantive law to achieve its targets. Therefore, procedural law is a means to an end. Procedural laws, procedural due process, contain notice of hearing. This one is the first issues that's including under due process of laws. Under procedural due process of laws, notice of the proceeding. You can infer Article 20, Sub-Article 2 of Federal Constitutions, and Article 108 Criminal Procedural Code. What does it mean when we say it's notice of proceedings or notice? How do we understand? Sila substantive kan afaan Amaaraatiin hiikame afaan Oromoodhaan substantive due process of law jechuun seerota substantive law keessatti seera baastuu gaafa baastu seerota gaafa baasanii jechuudha. Wantoota mirgoota dhala namaa faana walitti bu'an konstitushinii faana namaa walitti bu'an yoo ta'anii substantive law kuni challenge ta'an yookaan immoo akka inni haqamu ta'an. Kanaaf substantive law keessatti due process of law jiraachuu qaba. Due process of law yoo jiraate gaafa seerri qabeessanii harrisa namni ta'e uummata beeku yookaan immoo arbitrarily mootummaan diktaatara ta'e uummata gaafa beekuudhaaf seerota baafatu yookaan seerota ifa hin taane lammii isaa mootummaan hin dhiye protect godha jechuudha. Kanaafuu due process of law qabaatee mirgoonni dhala namaa heera keessatti kaa'amanii fi instituutii internaashinaal ta'e keessa kaa'amanii gaafa isaan mirgoota dandeettii yookaan namoota dhuunfaa miidhanii gaafa argaman akka isaan hafan haqaman Kan bagi kamera lagi mungkin istilah tiga film itu. Mana mungkin ulana ini mana mungkin federal ini mana mungkin wajib federal tiga itu. Hari waktu itu tidak bisa. Ulmu konstitusi kan wajib due process of law income, procedural due process of law, substantive due process of law income. Mante ini seri subsidi division ini sangat menjadi jawab karena kamu. Hafe mana mungkin ulana high court federal tak akan dimana mungkin. House of Relation ini bisa jadi sebuah House of Relation sebenarnya. Substantive due process of law sa, gaafa ilaalamu konstitusi kana mengerti wa right to appeal nama dhuunfaa kenname jalaa bisa gara itu dia dhaggeeffatan ni jiru hin jiru. Kanaafuu manni murtii waliigalaa federaalaa murteessinaan yeroo faaktii evidensii irratti yoo jiraate waliin fudhachuu hin danda'u kan inni waliigala fudhatu oolni yeroo of law yoo jiraate kaasishiin dhaggeeffata. Semua constitutional right isa limit restrict kepada wanti ini darsi tidak bisa saya kerja kewan di kumnas akan dihakale nanti aku mana mengunfah kami itu anggap baru itu kerana high court kerana mana saja kali akan jadi hakale that is substantive process. In United States Constitution Certificate dua waktu saja semua yang katakan film mind bukan mungkin gagap one satu bit. Yo ijoollee haati siisii akkasii wanta zalii arginu waan lammii biyya keenya kana Ameerikaa balleessanii jirani. Virgiiniyaan seera baasanii seera sanaan akka isaan hiikuu argan sterilize akka isaan taasisuu danda'an seera baasanii bu'uura sanatti manneen murtii sterilize ta'aa ta'a lammii keenya balleessanii jiranii taasisan. Sun booddee criticize ta'ee beektaanii natural right dhibee sanaatiif wasanatif qoricha barbaadu xumura jiraata malee akka isaanii dhalanne ilmoo arganii gochuun constitution USA faanas kan walitti bu'u natural law faanas waa walitti bu'uuf jedhanii labsiin staatii sana haqan maaliin giraawundii mana ta'e substantive process of law ta'e. In case of procedural process of laws, there are certain procedural rights of an accused. Certain procedural rights of an accused which injury in federal constitutions and law and international instruments are ratified by Ethiopia must be gone through due process of laws. Of those laws, the first one is of those rights. The first one is notice of proceedings. This notice of proceeding also recognized under Article 27 to Federal Constitution and 118 Criminal Procedural Code. This notice of proceeding refers the accused has a right to be informed. Sufficiently with a particular charge, charge የወንጀል ክስ brought against him or her. Therefore, Article 2 of the Constitution it talks about the notice, the charge which prepared by public prosecutor must be ahead of trial, communicated, informed an accused person. This charge must be prepared, we will see later on, in writing. በጽሁፍ መሆን አለበት አስቀርቦ አሰፕሬት። ስለዚህ በጽሁፍ የተዘጋጀ ምን እንዳደረገ የሚገልጽ ክስ ይደርሳል። ግዴታ ነው። ይመና በሪፎርማት ኢምፖፓይ ይመተማ አባራን ጋር በሪፎርማት አይሲቲ ሙዚቃው ይሁን ተጨምቁ ዋይ ይመና ያካ ይመተማ ሰናን ከከቡ ከነሙፊ አከከቡ ካ ስለዚህ አቃቤ ሕጉ ክሱ ሲመሰረት በጽሁፍ አድርጎ አስደሙ እንደ ኤክሰፕሽናል ሰርከምስታንስ ኦራሊ ይቻላል እሱ እናያለን። ስለዚህ አሰሩ the charge must be prepared in writing and public prosecutor has a duty bound to bring this written charge before the court of laws. The court of laws has a duty bound to deliver that charge which is prepared by the prosecutor to an accused person. መልስ እንዲሰጥ መከላከያ እንዲያዘጋጅ ይደረጋል። That this one is the very essential due process of law must be respected both by public prosecutor and other courts. This one is the notice. The second one is ሁለተኛው ምንድን ነው? ፕሮሰስ ኦፍ ሎው መብት ዋዝ ሰከንድ ዋን ማለት ነው። right to be heard, constitutional rights, right to be heard. Again, this one is the hearing procedure. You can see under Article 27(1) of Federal Constitution. This hearing might be in an open or public area, open session, or it might be the closed one, bi-cameral session. At what time? This one is as the rule, or criminal materials must be seen in our open sessions. The rule. The exception one is the closed one. Open session ማለት በግልጽ ችሎት ነው የሚታየው ተጨበና እንጂ exceptionally the closed when why when did a judge order the closed sessions why yeah ለምንድን ነው ክሎዝ ሴሽን ፍርድ ቤት የሚያዘው? በዚህ ችሎት ጉዳዩ ይታይ ይላል ኮንስቲቱሽኑ ራሱ ይፈቅዳል። As a rule, it must be the open one, but sometimes under very exceptional circumstances, the court order the closed sessions. Reason for rationale behind for closed session when it is violating or for the sake of protecting privacy or the concern of that. Not only this one in criminal matters, but also in case of civil matters, the court can order closed sessions. For instance, if the case is concerning the family matters, Danya Situnu, Gavicha Fichi, for instance, divorce in the Lamentin no Bulatu Baranams and why? Brothers, Lila, Sanaki, when the Mushroom, Liatan, Aso, the children of the Conductor. Lila was married in the Latin. Celesi, Fichi, Tayino, in the Zenechicus Lander, and the Bullet Road, and nothing other. The Dino in other. So Zidano, Yanin, in the Suyan Sutin Chick Idol. Advise market scientific problem konegan minimum marks can imagine. Okay, yeah, we try to differ several matter. Otherwise, our Shimani Yushika, question na I do indi taru tarika, Matara Kantadu, Uli paid to Haraga. That is because it's protecting privacy of that spouses. In case of criminal matters, when the court thinks that in order to protect the privacy of an accused person or that of the witness, eyewitness who came to or visiting court or testifying against an accused person, the court can order closed sessions. This one is the first one. What about the second one? National security. National security የሚያስፈልግ ከሆነ ለሀገር ማለት ነው። ለምሳሌ ቴሮሪስት በሆኑ ክሶች ላይ in case of terrorist ፍርድ ቤቱ ሌሎች ሰዎች እንዳይታደሙ ችሎትን እንዳይሩ መደረግ ይችላል። ምናልባት ርብሻ ሊነሳ ይችላል ሌላ ችግር ሊፈጥሩ ይችላሉ ተብሎ ስጋት ሲመጣ for sake of security, national security መከልከል ይችላል። እናጂ ፕሮሴስ ይከራከራሉ። ደደቸ ጩፋ jechuun ደደቸ namni biraa itti seenuu hin qabne jechuudha. Abbaa seeraa namoota himatan sana qofaatu dhiyaata. Abbaa langaa nama himatan sana ragoota qofaatu dhiyaata. Namni biraa bakka daddacha seenanii ilaaluu hin danda'anii jechuudha. Pilootisiin jechuudha. Kanaafuu gaafa wantoota piraayivesii nama dhuunfaa himatanii ragaa ta'anii dhiyaatanii yookaan nama miidhame sanaa abbaan seeraa miidhuu danda'a jedhee gaafa amane ijoolleewwan cuufaa gaafa ta'anii namoonni himataman daddachichi cuufaadhaan akka abbaa seeraa fi namoota akkasiin eeyyameef qofaatiin namni nutti ilaalu. Dhimma gaa'elaa keessattis abbaa warraa fi haati warraa gaa'ela kan eegamu yoo gaafatanii daa'ima sanii akka isaanii dhimma gaa'ela sana keessatti icciitii abbaa seeratti mana namoonni biraa dhaga'uu qabanii jedhamee daddachaa kan itti amanan yoo ta'e daddachichi baay'ee dhufaa. biyya sa kumara dimuta ya foto buku orang itu benda dimuta tradisi mana power itu dan yote ada cepat ini sudah kesadaran bangsa ada itu jadi bersikap azza ya kita so under chapter 1 is more about introductory meaning getting doesn't get jadi chapter 2 dulu dengan sejarah code bisa terlihat mandum teman kita code size kemana clearly identify mereka jadi code itu boleh mengenai itu dan semua berguna untuk